we've done a number of things in respect of the GPGC judgment there. One of the things we have done is to identify through the scheme of things and the processes and the evidence available, the people whose action and inaction have led or resulted in this judgment there. And we have reported them to the Criminal Investigation Division of the Police, Ghana Police Service, for official investigations to commence. Apart from that, we've also identified an international law firm who was contracted by government to defend them during the arbitration at the international court, and whose complicit negligence also resulted in this whole fiasco that we are currently witnessing. And so, yes, we've taken action against the domestic people and also the international people. And so we've not left anybody out, anybody whose action in the slightest way contributed to this judgment that we've taken action against that individual.
So a couple of people locally who had responsibility to perform to the Ghanaian people to ensure this did not happen, and then you said you have taken on a foreign legal firm.
Yes.
So what have you done in the case of the foreign legal firm before we come?
So in the case of Omnia Strategy LLP, which is an international law firm of high repute, we have reported them to the Solicitors Regulatory Authority of the UK, popularly referred to as the SRA. So the SRA is like the regulator of all solicitors and law firms in the UK. So more like Ghana's version of the General Legal Council, where if you have a problem with your attorney or your solicitor or any external solicitor or any law firm or anybody who you contract to perform such obligations as mentioned above, who do not, treat you well, or perhaps conduct him or herself in accordance with the regulatory requirements of the SRA, you can report them to the SRA for appropriate action. And so if you look at this case in particular, we have an external solicitor who we contracted, and the purpose of an external solicitor in an international arbitration is to have somebody who understands the local jurisdiction of where the arbitration is being held, has the right connections and right expertise, and also can defend you within the appropriate arbitration period as swiftly as anything else, because you are in Ghana when you are required to file processes. Sometimes before you can travel all the way, travel difficulties and all that could hinder your ability to file processes on time or to do things properly. And so when you have somebody who is living where a law firm which is resident where the arbitration is held and is taking action on your behalf, it makes things a bit more easier, and that is why the country spends millions of dollars. Omnia Strategy don't charge in thousands of dollars, they charge in millions of dollars. And so to contract this law firm, pay them millions of dollars to defend you, and then it turns out that the slightest window which the court provides you to file an appeal, this law firm, which you have paid millions of dollars, could not file the appeal on your behalf, and for that matter, we are where we are. And so we believe that Omnia Strategy's conduct amounts to what we call attorney negligence. Because one of the first things they teach you in first year law school is that you never blow a deadline. So when you are given the time by the court to file processes or to make a statement, to the court, or to apply for any motion to the court, you do not blow that deadline. You stick to the deadline, and if for whatever reason, if you are not able to meet the deadline, what you do is that you apply for leave of the court for extension of time. And in this particular instance, Omnia Strategy, even though they failed to file our appeal processes on time, they also failed to apply to the court for leave for extension of time. And part of, that is part of the reasons why the court threw the late appeal out and then fined the country, awarded legal costs to GPGC. And so apart from the $170 million that we're going to be paying, we are going to pay about $4 million to GPGC for the service of the attorney. We are also going to pay interest, which is going to accrue on this $170 million on a daily basis as long as this judgment debt remains unpaid. And so we are looking at an excess of $200 million, which the country is going to incur due to the negligence of Omnia Strategy LLP. And that is why we have asked the SRA to investigate them for this misconduct, and also appropriately, ask them to refund all attorney fees or legal fees that Ghana paid to them, because they did not discharge their mandate as solicitors. They failed to protect the interests of the country, and they were negligent in the conduct of their duty as external solicitors.
And I'm guessing you're also open to the probability of it being found that perhaps the instructions may not have come in time, that they were only following instructions and perhaps didn't get anything wrong.
Well, Omnia Strategy LLP was in court with us during the initial arbitration, and so it is not an instruction that was going to come from Ghana. It's an instruction which was read to the legal representatives in court that you're supposed to file these processes within this stipulated date. And so Omnia Strategy knew that they owe us a legal responsibility as our external solicitors to ensure that we file those processes on time. And so if for whatever reason we were not able to file on time, what steps did Omnia Strategy LLP take to ensure that we do not blow the deadline, or perhaps apply for leave of the court for extension of time on behalf of the country, which would have saved us this long legal tussle and also the monies that we're going to be paying? And so, any way you look at it, Omnia Strategy LLP as external solicitors, failed on their fiduciary responsibility to their clients.
I asked that because throughout the interviews I've listened involving the Attorney General, at no point did he say that the failure was a failure of the law firm. That it looks like even if there were clear communications as to even the filing of a review among others, every lawyer still takes their instructions directly from their client. The client that tells you can file this, you always go back to them to seek their permission before you go and file anything.
So now, you see, the actions that we have taken in respect of this matter is not to say we are 100% confident that so and so person is to be blamed for the woes of this country. No. The processes and the action that we have taken is also, to a very large extent, help us to understand what went on. Because for every front story that we are hearing or seeing, there's a back story. And so, if indeed the blame is not from Omnia Strategy and the blame is from Ghana, that's why it's a fair hearing. And so, Omnia Strategy will have an opportunity, because if you read the SRA guideline, when we filed a petition, what they said was that for the purposes of the other party, that's the purpose of fair hearing, they are going to serve a copy of our petition to Omnia Strategy LLP to respond appropriately. That is what they are saying. And so, Omnia Strategy will have their time in court. They will have the opportunity to defend themselves. And so, I, for one, am very particular. I'm looking forward to hearing the response of Omnia Strategy LLP to this whole issue, because that is where I think we'll get to the bottom of this matter.
That's fantastic. Of course, I'm also looking forward to their responses and the findings of the people you have filed the petition with. But you said there's another petition with the CID.
Yeah.
Which deals with the local players, the people who actually owe us a responsibility. You mentioned Attorney General. You say who and who again, and exactly why have you included them in the petition, and what are you asking the CID to do to them?
So first of all is the former Minister for Energy, Mr. Boakye Agyarko, who, as Minister, took the decision to terminate this particular arrangement with GPGC. And so now, we have particularly included him in the petition because he was a minister. He told us in 2018 that government of Ghana have reviewed a number of power purchase agreements and have saved this country in excess of $500 million. That was the communication we got from government. Now, in reviewing these power purchase agreements, what were the issues that informed Ghana's decision to terminate this contract with GPGC? Because if you look at all the emergency power purchase agreements we signed from 2015 to 2016, this GPGC contract was the most generous one. In fact, this country had, we virtually told GPGC that, hey, if you have the money, go and look for the money, come and build a power plant, and we'll buy the power from you. Unlike contracts like Ameri, where Ghana was supposed to provide an LC and other forms of guarantee to ensure that the contract takes legal effect. And so, this GPGC contract was a very generous one. Now, at the time the minister was taking the decision to terminate the contract, work on GPGC's project side was about 90% completed. So the fundamental question the minister must answer as part of response to the allegations you've raised against it is why he left power purchase agreement, which the companies involved have not even started work on the grounds as we speak. They have not done anything. They have not, expended any serious money on the project side. Why did he leave those contracts and decided to terminate this particular contract, which was about 90% completed? So I think that is what formed the core of the claims of GPGC during the international arbitration. Why Ghana decided to take this decision to terminate a contract that is almost 90% complete and decide not to respect its obligations under the termination clause and say, hey, we've cancelled the contract, we won't pay a dime to you, you can go to hell. I think that was totally wrong, and it's the crux of the issue that has cost this country this amount of money. And so the minister involved must have some response to this matter. He needs to further explain himself. And in fact, it's even profound to note that the minister's claim, the former minister's claim, that it was due to the recommendation of the Ahenkra Review Committee that recommended that he abrogated the contract has also turned out to be false. Because during the international arbitration, our own witness, which is Mr. Ahenkra, who we took to the International Court of Arbitration to testify in respect of this agreement, testified on oath that his committee did not recommend the outright abrogation of this contract. And so the minister, one has to lie. And it's very, very, very important going forward and investigating this matter that we take due note of that testimony given by Mr. Ahenkra at the International Court of Arbitration.
So, first, Boakye Agyarko, on the basis for the termination of the contract, of course, you say that was the germane issue, and that looks like why we failed miserably. So Boakye Agyarko, I've heard Attorney General. I'm guessing Attorney General is the handling of the matter.
Yes, the former Attorney General, Madam Gloria Kufu. We have included her primarily because she was the principal legal advisor to the government at the time. She was privy to the contract, and she knew that Ghana had an obligation under the termination clause of the contract to perform to GPGC. How she failed to reach an amicable settlement through proper negotiations on behalf of the country is something that we must get to the bottom of it. So now, if you read the inquiry review recommendations, one of the things they said was that if government has taken steps to terminate the contract, then government should take steps to negotiate with GPGC and settle them off. And in fact, the inquiry committee suggested through its testimony at the international arbitration that they recommended that through their negotiations with GPGC, they think that Ghana can negotiate and pay GPGC an outright cost of $18 million to cover the cost of the trains that they have spent and all the expenditures that they have incurred from the section of the contract to be. Okay? The second issue is that GPGC themselves, after the contract was abrogated by government, approached government and demanded a settlement of just $23 million.
Actually,
The Attorney General was very much aware. So then how we move from an outright it's nothing but due to the negligence of the then Attorney General, who decided not to perform her obligations or the obligations of Ghana under the termination clause of the contract. And that is why we are here. That is why we have included her. We have also examined the current Attorney General because of his fruitiness in defending this country at the International Court of Arbitration, where he went and performed his functions as AG, just like he's doing in the local court, and support of the court, just like he has back home here, and failed to file prisons on time, failed to put in the necessary defense and appeal, and due to that, this country has been awarded 170 million judgment debt. And so, the criminal negligence of these three individuals can never, ever be understated or overemphasized. And so, we want some investigations into this matter to bring closure to this particular matter.
Well, so Boakye Agyarko, Gloria Kufu, Godfred Dami, 3.
Yes.
Okay. You want the CID to investigate and leading to what?
Leading to one, then we want these people to absorb the 170 million judgment debt that their actions have incurred for Ghana. We must share the $170 million for them to pay, or they get prosecuted and go to jail.
They should pay off our liability that have come out as a result of the court case.
As a result of their inactions and inactions. As of the result of their actions and inactions. Not the court case. Because this matter shouldn't have gone for international arbitration in the first place. This matter shouldn't have gone to the England court in the first place. It should never have. So they must pay the money or they go to jail. We can look for some very nice air-conditioned cells in Sawam and then just let them go and enjoy the rest of their time there. Then it's very, very important because we cannot continue to spend these huge sums of money on judgment debt. And when the country is in dire need of resources, look at our infrastructure, educational infrastructure, health infrastructure. Then we need so many things. Look, recently when the flood when the rain started coming in, look at our city. Are virtually submerged under the floods. This country needs so much, development. Nursing mothers who go to hospitals are practically sleeping on the bare floor to get treatment or to be nursed. Can you imagine? So, do we know what this $170 million can do? And so you can't be a country like Ghana with such huge, economic gap, huge infrastructure gap, huge challenges in your economy, and always be wasting money on judgment debts, needless and avoidable judgment debts. We cannot do that. These people must be sanctioned one way or the other.
And I'm guessing you've listened to Mr. Boakye Agyarko. He's spoken to at least one or two media houses. His point is, well, I was just obeying cabinets. I couldn't have said no to what cabinet said. Cabinet said I should do it. I have done it. Why are you people seeking?
So why didn't cabinet terminate the contract themselves?
He is the energy minister. He represented the president in that, so he has the duty to do that.
So, you see, Senator, he had a choice. If cabinet takes a decision, as minister, if you do not believe, or if your training as a lawyer does not, yes, Senator, hold on, I've been stopped by the police.
Oh, okay. It seems you have.
Yes. Yeah, hold on. Yes, hello. Yes, sir. Yes. Good.
It's an interesting one. So we'll get back and listen to Mensah Thompson to conclude that the conversation. Samuel Kona says he can't go for fishing. Echo the game says she did. No, actually we haven't concluded. I was just getting his thoughts on. Can you hear me?
Yes, Senator.
Has the matter been resolved?
Oh yes, they're just a normal routine checks on the streets.
Okay.
Yeah.
So you were speaking to Boakye Agyarko's response that.
Yes. So Senator, if you're a minister and cabinet take a decision which you disagree, which you believe that it will not be in the benefit of the state, you don't go ahead and do it because it's a cabinet. That's why you have a right to resign. That's why you have a right to resign if you don't believe in the action and the decision cabinet is taking. So once you go ahead, accept cabinet decision and write the letter to terminate the contract, append your signature to the contract, to the termination letter, then you are so liable. You are as liable as anything else. And so you should go to the investigation team and tell them that his defense is that it was cabinet decision. Then we'll see what will happen.
Well, that's interesting. And also, let me end with this last one, because it's one of the things that have come up. And if you realize, the former power minister, Dr. Kobna, has also have to defend himself very sternly, because they all say that it all goes back to the agreement. The agreement was just irredeemably bad. It was the reason they lost in court, and it was not because they didn't have they tried their best and it wasn't going to work, because it's that agreement. Do you think about including him in the list of people to be investigated?
So now, we are not paying the judgment debt because somebody signed a power purchase agreement. We are in this mess because somebody took a decision to terminate the contract and failed to perform his obligation under the termination clause. So, as far as we are concerned, we don't see anything wrong with signing a contract. So now, is there any law in this country that says you can sign a contract? You can sign a power purchase agreement? Is there any law that says that? Two, say now, this contract was ratified by Parliament. I'm not saying cabinet. This contract was an international contract and was sent to Parliament under Article 1815 for parliamentary ratification. I'm not saying cabinet ratification, I'm saying parliamentary ratification. And if you read, the Supreme Court ruling on the Balkan energy, Waterville, and other, issues that went to the Supreme Court. In fact, the Supreme Court ruling is very profound. The Supreme Court said in that ruling, in the Balkan energy case, that a minister merely signing a contract does not automatically grant legitimacy to that contract. especially under Article 1815 contract. The minister appending his signature to that contract does not automatically grant what we call legitimacy to the contract. In fact, the court held that the contract only becomes legitimate and takes effect after parliamentary ratification. And so that contract signed by Mr. Kobna as former power minister between GPGC was never legitimate until Parliament had ratified. So the ultimate legitimacy to that contract lies with Parliament. And so here, Mr. Donko's liabilities in respect of the Supreme Court ruling was shifted to Parliament and not to himself. But in the Boakye Agyarko's case, when Cabinet took a decision to terminate the contract, as minister, did he go back to Parliament, which was the institution that approved the contract, to seek the opinion of Parliament? Did he do that? Did he do that? So, we sign a contract, we take the contract to Parliament for ratification. Now you want to terminate the contract. You say, I won't go back to the people who ratified it. I will write a letter myself and terminate it. Now you are saying that it was cabinet decision. You see, so Senna, he's so liable. He could have shifted that liability to Parliament if he had taken that cabinet decision to Parliament. He has written to Parliament and said, look, Cabinet has taken a decision to terminate this contract. And as the House who approved this contract, can I have the legal opinion of the House as part of the process of consultation? That's what he should have done. He didn't. He only terminated the contract and went to inform Parliament that he has terminated the contract. So, Senator,